Hey, folks, welcome this week to the Matrexit discussion group call for tactical sovereignty. And what we are doing is we are going to be going over some legal research so that people kind of have a little bit more of a handle of what's really happening when they step into court or if they have to answer an affidavit, anything like that. So give you some idea of what's happening because so much of the information that is put out to people in social media is just completely false. And I know there's so much of it that I read or listen to that you can tell right off the bat that these people really have zero experience. They're just guessing at all this stuff. So that's what we want to do. We want to kind of unmuddy those waters for people so they are really getting actual, true knowledge and not just information. Like I've said before, if you look at like what the three-letter agencies are looking for, they're actually looking for intel, looking for intelligence. Information is the lowest level. There's lots of it out there, and half of it's garbage, if not more. And the next step up from that is knowledge. That's stuff that really works. It's more apt to be factual truth. And then there's intel that they look for. Intel, though, is generally secret knowledge. So we have to think about that in those categories when we're looking at different, say, info that we're going over. Is this stuff real or is this gold? You know, is it diamonds or is it dung? And so we want to come forward with diamonds here. And we've got Jeremy with us also this evening. How are you doing, brother?
Thank you for having me on. I'm doing pretty well, brother. I'm kind of speechless that we're here, and thanks for the introduction. And the things that we're doing is just so big. It's kind of exciting. You have this book out that you've told people to get, this Gilbert's Law Summaries on the legal research. If anybody is trying to understand that, I guess I could go over a brief beginning of the chapter if you'd like to kind of want me to nutshell that, if people could want to get an introduction to it, if you'd like.
Yeah, sure, absolutely. And I recommend people as well, you know, when they get that, dig into the beginning of it. It's called capsule summary, and you're going to get definitions and things in there that it's going to tell you what things really are as opposed to what you've been told. You know, things like equity or common law and facts regarding law. And that's really a good body of info that you want to be able to have your mind wrapped around.
Yeah, it basically kind of teaches you how important it is to understand the language of the court, because it's put in a higher language to confuse the common person. So what you've got to do is you've got to understand a lot of new words because it's a new profession. And once you start to understand that, and you can understand what's going on there, you'll be able to understand what they're saying and understand what to do.
You know what, Jeremy, talking about new words and things like that, something I've wanted to mention, and I always forget to tell people, it strikes me very interesting that what we hear most commonly is how they've changed definitions or how they have their own secret language or whatever. And it would seem like it's been changed or seem like a secret language because the definitions aren't the definitions we're used to. However, I notice myself going back, reading books that are, say, 100 years old or more.
Yep.
It is, I'll tell you what, for instance, if I spend a day reading a couple chapters of Law of Nations and then go and try and have a conversation with an average person, it's like I'm talking to a toddler, you know, exactly. Because, yeah, the level of language has gone so far down. And so it's not necessarily that this is a secret language they're using or that definitions necessarily have been changed, because definitions do morph over time. You know, for instance, like looking at the word gay, it used to mean happy. Now today, gay means something completely different. You know what I mean? Yeah. But these words, these terms in legalese are pretty much based in Latin. And Latin isn't called a dead language because it's no longer used or because it's old or anything like that. It's termed a language because those definitions are fixed. They're solid. They're going to mean the same thing 100 years from now that they mean today. Like I said, it's also not because if the language isn't used, because you're seeing it used in the judicial system, you see it used in medicine, you see it used in agriculture, and they all use it for that reason, because the definitions stay the way they are.
It's just very, very you can't stress going into a new profession and trying to not understand what they're trying to say in there and how dangerous it is. So what's scary is we're hearing a lot of people from the public that are coming at low level, and because it's confusing, it's easy to manipulate the people to do things that are basically not going to help them. So what I believe what we're trying to do here is trying to help other people understand that it's not so scary. It's not so such a mystery. This is easy stuff to do. You know your facts. You can make these arguments. You can defend yourself. You can express yourself in a way of defending your rights and do it without a lawyer. And really, if the people started to understand this, we could really make a lot of difference in this country. But the thing is it takes this foundation to make it happen.
Yes, absolutely. You have to have a foundation. For instance, if I was to sit down and talk to a nuclear physicist, okay, that gentleman or lady could feed me a total line of crap about how nuclear physics work, because I know nothing about it. And it's the same thing with a lot of this knowledge regarding the judicial system, things that you should have been taught in high school, but they don't. You know, words and terms you should have learned, at least in high school, that you didn't learn. And so people go out and they see these gurus or whatever saying, oh, you got to do this or file that, or, stand on one foot and throw salt over your other shoulder for luck, pretty much. And you're going to believe them because you don't know anything about it. So that's what you want to fix.
Yeah. Really, you want to understand it's a game of chess. Okay. And you got to understand it's also a type of a poker game at the same time. Yeah. You've got a lot of things that you can do, but it's all in the public speaking realm. And if you're good at debate, and if you're good at closing your arguments, or if you're good at sales, this is really your avenue to help a lot of people and help yourself at the same time. But at the same time, you've got to educate yourself to get there. That's the biggest thing.
Yeah. And I want to say that, there's something like some very basic things, and this is what we want to cover. Some very basic things that doesn't even, I don't know, doesn't really trigger in people's mind. They don't think about it when a situation occurs. But they have to realize that, for instance, if a criminal case is going to be brought against somebody, there's elements that are required for that case to stand. One, there's got to be a law. There's got to be a prohibition against whatever was done. There's got to be mens rea. There's got to be your state of mind. There's got to be the actus rea. There's got to be the illegal act. And there's got to be causation, those four elements. And so people need to look and see when something comes at you, check to see if it has those four elements. Just like I say, if you get a traffic ticket, look up the statute that's written on it. Make sure that they're charged with the correct offense. A lot of times they're not. Those officers might have two or three favorite things they go after, and those are the only numbers they really remember. So they'll just write it on there, knowing nobody will check.
Well, yeah, you want to break the statute down into elements, usually, which you're looking at. If you're trying to make an argument, the legislature has put forward certain statutes. The statutes are written in conclusions. So what you want to do is you want to make sure to get your fact pattern to make sure that your facts, based on your situation, really don't ever aim your facts towards it. Always just put your facts out, so you can identify what your issues are. You may have more issues than just one. So that's why it's very important to stress that. But once you get your facts out, you'll notice that the elements of the statute will have, you have to hit this, hit this, hit this, and hit this. And there'll be 4 or 5 of them. Maybe there's 3, maybe there's 2. You have to see if your facts hit those elements. If they hit those elements to the where those conclusions are activated, then you've got a winner. And that's really where this whole game's going, and that's how the chess pieces are activated in the court system. And it's not so complex as long as you're going off of the interpretations of the Supreme Court and the appellate court of your state. You really want to stress that. The reason why is because those are the holdings of the state that they really enforce with their own constitution. You don't want to go into state court and like flex the U.S. Constitution. That's not the right venue. So you want to use the proper wording. You want to come in and you want to make sure that you have the state court for where the state that you're in, and then emphasize the argument that you're trying to make. Sometimes you'll find one that is not anything like you have in your own state too. And when you run into that, you might find something to where you could bring an avenue in from a different state to be able to argue that angle. I would say that's probably the only way it would be persuasive, because they've already ruled on that issue. As long as you get the understanding of why they ruled that issue, and you kind of phrase your legal analysis that way, you shouldn't have a problem getting them to agree with you on that. But the problem is your fact pattern has to support it. Absolutely. But no, I would say that it's very important to make sure that where you're at, look at where you're at in all of these situations, look at what your rules are, look at what your constitution says, look at what your statutes say according to the situation. And then you have to kind of get a game plan written out. What am I trying to do here? That's the kind of concept that you're looking at when you run into these situations. Then you also have to look at the other aspect as, what are they going to do if I do this? So that's why I would say it's in a phraseology of trying to understand chess and playing it that way.
Yeah, absolutely. You have to imagine what the next move of the opponent's going to be, on the other side of the court. And when you're looking at these cases, which is what part of what we want to show here, is like Jeremy said, try and make sure that it's a case from within your state. Jeremy and I were talking earlier today, and I was talking about a article put out by We Are Change. And like I try and remind people every week, always look in the description box there on Talkshoe. I'm going to throw a bunch of info down there. I'll throw this article down there that I wrote basically as a rebuttal against their article, because they wrote an article that was titled Supreme Court decides no driver's license, registration, or insurance is necessary, something along those lines. And I went into that article and started shepherdizing some of the cases that they had in there. And I got to like 5 or 6 of the court cases that they had listed, and I didn't find one that pertained to driver's license, registration, or insurance. One of them pertained to whether or not somebody could have a march in a city in the South for civil rights. Another one was regarding whether or not a woman was able to apply for state benefits because she had just moved from another state into that state. I mean, none of the arguments that I saw, in fact, none of the quotes they even had in their article were even in any of those cases that I looked up. And none of those cases also identified anything regarding registration, insurance, driver's license, anything pertaining to that. So you have to be careful that whoever you're getting information from, when people are saying, oh, use this case, I've used that case, whatever, look that case up, shepherdize it. And don't just look at the arguments that they were making. Look at the conclusion of the court and what the court actually says in their decision.
That is so important. And then that at the same time, you've got this AI machine that's coming out, and people are using it, and then they're making these arguments, and then it's giving it fake case law too. And oh no, you're running into the same situation. The person is trying to make an argument. Granted, it almost sounds valid. However, they don't even have anything to support the argument. You don't want to be in that position, especially if you if you're trying to file motions on your own behalf, and think about it, if you're working for somebody else too, you don't want to do that to them, and you always want to put it yourself in their position when you're working for somebody. Do you want to be in that position? No, that's going to make you look absolutely incompetent, and that's not where you want to be, not at all, especially when you're trying to actually represent yourself without a lawyer, because they're going to just sit there and totally look down on you, especially after that. They may even get you to say that you can't file motions and you need an attorney. Those are very dangerous situations to be in. So especially when you're trying to say that you're competent, they could be like, they could really stress that against you. So that's why it's so important to read your case law, and it's so important to check things that people are showing you. If you don't do that, you are basically chopping your feet off before you started the race. Don't ever do that before you start a foot race. It's just not good. Anyway, I believe that it's very important to read that. I've seen so many in the last 17 years. I've had people come out with me with case law. I'm telling you, I read it off the cuff and was like, wow, that's fascinating. And then I passed it to somebody, and then those people like have started occults, and I don't even understand what has happened. And I really feel sad, because I try to stress and explain it to them, and they won't hear it, even if you showed them the case law now, because they went so far. And that's why it's dangerous. Do not give out false information. You'll feel bad about it later. I mean, that's why you want to investigate this stuff.
Yeah, and it's going to make you look extremely foolish. And like you said, you don't want to be put in a position, if you are representing yourself, say pro se or impropria persona, you don't want to put yourself in a position, because judges will come to a point where they're like, you don't have any idea what you're doing. You have to get an attorney. You can no longer represent yourself. You're incapable. I was telling earlier before the recording started, I was listening to a case yesterday with the same exact scenario. And the majority of this time before the judge was the judge trying to figure out how to get this guy an attorney. And the guy was saying, no, I can do it myself. And he's like, well, I'm looking at what you submitted to the court, and you're submitting law that comes from the criminal rules of procedure. He says, this is a civil case. You can't use the criminal rules of procedure. And I don't think the gentleman even comprehended what the judge was trying to tell him.
Yeah, it gets really bad. I've seen people that didn't understand what representation hearings were, where they expected to have a new attorney appointed to them. I've seen all kinds of different things. And it's hard to see, and it's hard to watch. And sometimes I think, was I like that? Was I not listening? Did I not understand? Was it that bad? And then it really humbles you. You know what I mean? When you see it like that, because sometimes I've seen myself, like I've saw past recordings from myself when I first thought I was getting somewhere, and I was cringing now, I mean, there's a lot of growth that goes through a lot of this, because we have to practice though. I mean, you get better and better with each argument, and you get stronger and you get more confident. But it just starts taking the avenue of thinking this way of, maybe I should base my ideas off of what the holdings are from the higher court and how they ruled on these rules, or how they ruled on this statute, or how they ruled according to the scenario. And based on what they ruled, how does it apply to my facts? And then if it aligns up, then hey, you got an argument. Well, let's go show one that it doesn't, that shows you that they ruled against it, or show you that you have another one that's where they ruled against it, but all the fact patterns show that you're still getting it based on your facts. As long as you can do that stuff, they see you done all the work. They don't even have to think. All they got to do is sign the order. And that's kind of where you want to be. And that's where I try to make sure that people understand, don't go attack the judge, man. The judge is your friend. He's the guy that signs the orders. Do not do that. That's like, hey, I'm going to go play a basketball and I'm going to go knock the referee out so I can go win the basketball game. I mean, what basketball game has ever been won that way? I don't know. It's just common sense to me.
Yeah, try and do some of the judge's work for him. Make it easy for the judge to rule in your favor. That's what you want to do. Did you have any particular section, like of the beginning of the Gilbert research book, that you want to go over this evening, Jeremy?
Well, I mean, I don't want to rush people into it too much, but at the same time, the ideas that you're trying to get is you're trying to separate the idea between civil and common law and criminal law. You have to understand the difference. And then you also want to understand what family law is and then probate law and understand there's a big section of different rules that apply to these different arenas, but it's all pretty much the same thing. One topic at a time, one person speaks at a time. As long as you understand that, you'll be able to run through your things pretty well. But I would say get yourself a notebook and get yourself a dictionary and try to understand some of these new words that you're going to run into in your dictionary. But the thing is you you really have to understand this new language. I remember trying to be an insurance agent when I was 23, and I wasn't really getting it at first. I was trying to learn the language, and how are you going to sell insurance if you don't understand the language? So I had to write down every word. That's what was for myself, so I could understand it. And then I had to associate it to something. Um, that's really why this is so important, is so you can understand what you're about to go into whenever you go read the rules or read your case law, and so you can understand what you're trying to say.
Yeah, that's like I tell people that if you're going through like a contract, for instance, because you're going to find all these terms, these same things are all going to be in contracts, and where you go to sign it on the contract, it will say, I understand the terms of this contract. Well, when it's saying, do you understand the terms of the contract, it doesn't mean, do you comprehend what this contract wants you to do or not to do or something like that. No, do you understand the terms? Do you understand the words and the phraseology that's included within that contract? Because if you don't understand those, you don't understand the contract.
Yeah, that's exactly it.
Um,
It I I
Go ahead.
think that the aspect of writing down certain topics, maybe if you can associate it to something. Say you want to go into a discovery. Say you want to remember a word, and the word's really hard. You can't understand it. Say it's something like, maybe it's the first time you ever heard the word conclusory before, or res judicata, or discovery, or deposition, or dispositive. Maybe those are the first times you've heard those words. You don't know how to use them in a sentence yet. You're like, okay, let me write these down. Let me see how to use that in a sentence, and then practice it. And then you'll notice that after you start using it, that other people use it all the time, and you'll be like, wow, this is amazing. And then when you can start using that in application, you can use it yourself too, and that's easily understood by them. You're going to get your motions granted. You got to understand the language of the court, because the language of the court is the only thing they are going to grant their motions under most of the time, because that's what they understand. That's the procedure.
Yeah, he used the word there, conclusory, and I think that's probably one of the biggest things that I see, for instance, in affidavits that people write. And like we
Yep.
said last week, you mentioned, you can't just send out affidavits willy nilly to whoever and think that they're required to respond to you. That's not the case. But when you're writing affidavit, I notice so many times they are chock full of conclusory statements. Do you want
Yep.
to go over that, Jeremy?
Conclusory statement is basically making a conclusive statement without having any supporting facts to make your conclusion. You can say this person assaulted me, or this person um, robbed me, and then that's a conclusory statement until you brought your facts in to support that conclusion. Now, you have to understand there's a frame of art here, and the framing of art is the terms. So you got the facts of, explain it in detail. Uh, what happened to cause the assault? What happened to cause the robbery? And explain that. and then be it very, very meticulous. Explain the mendacity of the person that committed the thing because of the way they did it, or of that, so you could show that it was premeditated. Those are big issues when you're trying to explain this stuff to show the argument of intentional. And if you don't understand that, you can really get yourself in trouble because you're just making conclusory statements. And the court is trained. You'll read through a lot of studying under Fleming's and all these other professors. If you invest in any of that, these professors will teach you that it's really important to focus on your facts, because if you don't do that, you won't be able to invoke your conclusions, and they are trained to not even look at conclusory statements at all. So basically, if your document is filled with conclusory statements, you have written nothing, and they will not even entertain looking at it. And that is just a fact.
Yeah, that's why you'll hear people say, "Oh, they totally ignored my affidavit." Well, that would be a very good reason why. And as well, also writing statements that are basically judicial decision statements, like Jeremy mentioned, assault. Well, you can't just say somebody assaulted you. Well, for one, assault is a judicial decision. They'll decide whether or not they assaulted you. You have to tell them what actually occurred. You know, I was sitting out in front of my house in a chair, I was minding my own business, and my neighbor Bob came over with a baseball bat and swung the baseball bat overhead, and hit me in the shoulder. You know, drawing blood and breaking my collarbone.
One can
That's
conclude that it was intentional, and that because he did it with enough force to cause harm.
right. Exactly.
That right there will make it. Okay, when you come in and you say he assaulted me on Wednesday, yeah, that's not enough. You have to get in detail, and that's what you'll find from the Iqbal versus Ashcroft case. That's changed the country. You really want to pick that up because there was a Muslim guy that was trying to sue John Ashcroft, and they were able to dismiss it based on a failure to state a claim. Now, a couple cases that were already, or case that was already in there was the railroad, Twombly versus the railroad company. And you also kind of want to read that too. It all has to do with the failure to state a claim. Now, the other sister to that, there's another argument that's an objection. These are objections that you bring up before trial. You can throw the case out like that. If you read it's under Rule 12. There's another Rule 12 for criminal, and the sister to it is called failure to state an offense. So you've really just got to understand that conclusory statements don't work, and that's your strongest argument. That'll just knock out your case, but you've got to make it right and show that the elements haven't been met. If you can do that, it's a very easy motion to win, but it's has to be well articulated based on your facts, showing that it doesn't activate that that statute. All you got to do is be one off, and it's a fatal flaw. And that's what the case law says. I'm not telling you from my own experiences. I'm telling you from judges across the country. You can look this case up about failure to state an offense, and it's a fatal flaw to indictments and charges against people. I think it's a great argument because it knocks cases out instantly. So you just have to make sure that your argument's on point and make sure that they rule on them, and try to answer their reply. But you cannot let them win if you got your points correct. You'll have truth on your side, of course. But the thing is it's very important to understand how important your facts are when you're running into these situations. And it's one of the biggest things that most people don't understand when they're running into representing themselves. They don't even want to tell their story. They just think all the laws apply, and they don't understand that they have to make the facts apply to make the laws apply.
Exactly. Yeah, you have to realize what you're doing. You're stepping into a situation where this other party, being the court, being the judge, they have absolutely no idea about the situation. It's like something that it's a brand new story being brought forward to them. And so you have to be able to describe that story and frame it so they can comprehend exactly the elements of what went on, so they can also determine the illegal elements of that as well. And at the same time, I want to state this also. We also have to realize what not to do when you
Yeah.
go in there. And what not to do can be seen, I think, probably all over YouTube. Um, there was a case with the Montana Freeman years ago, up in Montana, and they were using the old Patriot arguments about, the seal on the wall, the gold fringe flag, the judge there in the robe, um, and the judge stopped the case. And gosh, I wish that internet had been around at that time. People did have cell phones at that time, so this could have been recorded. But the report is that the judge stopped the case and said, "Okay, we're going to take a recess." During that recess, he took down the flag, he took down the seal, he took the robe off, and just came back out in his shirt and tie and sat down and said, "Okay, we're going to resume the case." Because those elements that everybody screams about all the time, that is not where their authority is derived from. Those things are just decorative pieces. That's all you're looking at. It has nothing to do with their authority. So it doesn't matter if those things are in the room or if they're not in the room. And I've just listened, I'm sure Jeremy has too. I've listened to too many cases where, unlike what Jeremy was just describing about naming the elements of the situation, instead people went in and they made all these patriot arguments and never once even mentioned the case. There's cases I've listened to that I had no idea at the end of it what the case was even about, because
Exactly.
they did not bring up one of those elements at all.
That's the main thing. Somebody said it to me once. It was an old timer, and he was telling me, "Hey, man, I love what you're saying, but there's this thing. Nothing is obvious. Not, and could you be a little bit more descriptive?" And I was just like, that's a good point. I had worked on a case about a person getting their right to speak taken away. I read a case, I believe it was from the appellate court in Alaska, and it had three elements that were emphasized, and those things were, the first one was he had to not quote religious dogma or UCC code. The next one was that he was not supposed to be disorderly, and the other one was he was not, or he was had to be a legal prognosis by a doctor saying that he can't represent himself. Now, all those three had to be activated in order for him to not be able to represent himself. He didn't do any of those things, so he was able to get his right to speak back. But the thing is that was the criteria in which they took your right to speak away, and how important that is for people to understand, because I've seen people go turbo in there and they never even thought about those boundaries at all. And wow, you really want to understand that there is a form of respect here. You want to explain that these are people too, or you want to understand these are people too. And as long as you understand that, kind of treat them as people, trying to be thoughtful. Hey, you may not have seen this. Let me show you. Those are the more those are the type of approaches that are going to get uh, the proper feedback that you're wanting. I would say that as long as you're treating these people as people and you're at least trying, and you're doing your job well, you will be rewarded. But it's going to only be hard work that's going to get you there. And I can't tell you that it's going to be an easy way to get there, because you're going to have to educate yourself, and then you're going to have to learn the rules. You're going to have to learn how to talk to these people. You're going to have to write it out. You're going to have to do it in respect. You're going to have to understand that you can come in here and do a lot of good and save yourself a lot of money, but you can also damage yourself if you don't understand your issues. And don't rush. Never rush. Always take your time, because if you don't understand your issue, you're false firing, and don't do that. And always be prepared to close. Don't go in there winging it on anything. If you're really trying to get that granted, you have to think about what they're going to respond with. You have to think about how you're going to respond to them, in a way that it's going to be receptive to the judge to be able to grant your order to. You have to understand all of the elements in your audience and where you're at. And it is a fighting mentality because it's an adversarial system. But there is a form of gentlemanly respect that has gone through the system for years. And as long as you're using intellect and you're actually accurate, that is well rewarded. And I'm not gonna deny that at all. And I try to tell that to some of my friends. It doesn't matter where you come from, it doesn't matter what nationality you are. If you're right, you're right, and that's just how it is.
Yeah, a lot of this is going to seem, because, like I said, it's almost like a new language to you, and there are a lot of things here you got to learn, but it's really very basic and more simple than you realize. It's just a matter of comprehending these elements so you can do them correctly, and realize as well, as far as being respectful, different judges will have different rules for their courtroom. You want to find out from their clerk. I mean, a judge will have their own personal clerk. Find out from their clerk what rules that they follow and what rules they necessarily don't follow. Those are good to know too, because that's going to get a judge a little bit more on your side if he sees that you're being attentive, to his rules. It's just knowing that, your girlfriend likes a certain type of flower, you know what I mean, and you bring it to her. Same exact idea. Now,
Exactly.
when I don't want people to think that, oh my gosh, this is too much, and then what do you do once you know this stuff? If you've got these elements mastered, I've got a friend, or I guess a friend, an acquaintance, whatever. He was probably held more trials than any other attorney in the state where he lived. And he had one, and the reason why is because most attorneys will just throw you to the wolves. They want to plea you out. Well, this guy never wanted to plead anybody out. He wanted to go to trial. He liked to fight. One of the cases that he had was a situation where a man had gone to his truck, pulled out a double barrel shotgun, and unleashed both of the barrels on another man. I will just say from above the chest, I'll put it that way, and then took the other man a few hundred yards and threw him into a river. Of course, this guy was being brought forward with murder charges, of course. Well, guess what? This attorney that I'm referring to represented him and got him off on those charges. As horrendous as all that sounds, when you know the particulars of how things work and what things within a case can be used in your benefit, you can move a mountain.
Yeah. That's another example of facts being able to be supported. You're going to have a reason why this has happened that drew this person to this situation, and where a jury heard it and was like, "What? Oh yeah, yeah, he didn't do anything wrong." Those are things that happen, and that's kind of it's just a reality. The facts make a difference, and they always make a difference. You can't get around that. So the basics of it is, out of the facts arises the issue. If there is no facts, there is no issue. That's what Professor Flemings always likes to teach, on the aspect of that maxim of law is words to live by, especially when you're trying to represent yourself in any short shape or fashion. The other thing that I would like to stress is, whenever you're watching attorneys, a lot of these people have aspirational accolades, like they went to school, they became these lawyers, they have this degree, they went in and they became officers of the court, they've passed the bar. Okay, so you've got to understand that their motions are not your motions, their forms are not your forms. You have to be factual. You cannot ride on your own capacity accolades because you don't have any. That's why it's so important to make these arguments off of the facts and to be clear and concise. Um, that is so important. Because you can walk in and you can see an attorney be completely wrong. He could say, Chewbacca had lunch today at 5 o'clock, so therefore you should grant my motion. Has nothing to do with the motion at all. Granted, it's because he's an officer of the court. If you don't understand that, you're going to fall into the trap of not winning. You have to understand that when you're looking at your failure to state a claims arguments, it's because they didn't state their facts correctly. So you got to understand that, and when you're making your arguments, when you're writing your motions, do not follow after what they're doing in the aspect of writing conclusory, because you're not going to get there. You're only going to get there with your fact patterns. So you come in with your statement of facts. Your statement of facts will come and look beautiful. Then you have to understand what your issue is, and then you write on your issue. When you have your issue, you'll go, oh, okay. Now, wow, that's my issue. Now you can come into your legal standard and see what the courts have said and interpreted it on that issue. And then you go, oh, okay, well, this is where my facts are. This is where it leads to that conclusion. And this is your analysis. Now you can say, I request based on this ruling that they and the facts that based on the reasons above, or that the court should grant this motion. And is the facts there? Is the law there? Is the issue there? Yep, we're giving it to them. And that's the simplest way I could tell you how to deal with these guys. Don't look at them as enemies. Try to understand that this is a profession, and that's the way they do it. They want to be professional. Treat it professional. You treat it professional, and you'll get the same respect. If you go in there negative, they're gonna get on guard too. And that's just the way it is. So it's just a natural atmosphere, but at the same time, it is adversarial. And so don't ever give up too much information about what you're going to do next. What I meant with being poker, that's what you're playing. That aspect right there is very important, because when you're asking questions, when you're deposing people, you don't want to give up what you're doing. You want to, I've learned this from experience and failure. You want to write your stuff down and then kind of expose it later. You don't want to go too much into it. You do want to confront them about it and see what their answers are. But you always got to understand, when you expose these type of things, they could negate these issues. And if you don't tackle the new way they negated it, they might get away with that stuff. So you have to understand there's a can of worms that can be answered or can happen whenever you're asking questions. Form your questions correctly when you're deposing people. It's an art. You can have fun doing it. And if you do it correctly, you can win your case rather quickly if you do it right. But because then you're getting them to agree to the facts of the case or what you're trying to get them to say. You can do deposition questions written in a criminal case. You can also do them in civil cases. There's forms that you could probably find online for that stuff, but those are things that you're going to find in the discovery process of a court case. And the discovery part of your court case is really where you get to put evidence in, or where you get to knock evidence out. And that's all the stuff that's going to be heard at trial. So you have a way of being able to ask for certain things. And if you don't ask for them, you're giving up. And that's just not what you're trying to do. You really want to make sure that you're framing the stage of what you're trying to admit into evidence, what you're not trying to get into evidence, what you're trying to frame the platform for the stage of what you're going to present to the jury. And I don't think a lot of people understand that. And that's kind of why I went over it. But other than that, is there anything we should else cover, or let any people ask questions or anything?
Yeah, I guess we could open this up for questions. Tell you what, I will unmute the board. So when I do this here, if you don't want to be unmuted, make sure you've kept yourself muted out. And if you want to ask a question, just please do not step on each other, one at a time, and announce you are first, if you would please. Thank you all. So everybody is now unmuted. So you can double check if there's background noise coming from you. I might have to mute you out.
Woo!
Such as if you're playing me over a speaker, it's going to feed back like it's doing right now. Thank you, Tracy. Okay. If anybody had a question, feel free. If not, I think we've given good knowledge for people to wrap their mind around this evening. When they start learning and start reading some of the knowledge that's in this book. And at the same time, like I said, once you start comprehending this knowledge, when you see somebody posting a court case and they say that the decision of the case was this or this, and you can read that decision and you'll be like, wait a minute, there's no way a judge said this. This is not even the language they use.
Yeah.
And so you can start, your BS meter goes off immediately.
Yeah, you'll be able to identify issues. And that's the thing, is you're trying to issue spot here. You're not trying to walk into situations and be completely blind. You know, the blind leading the blind run into the ditch, as the Bible says. I think there's a lot of truth in that.
All right. If anybody had anything, speak now or hold your peace until next Sunday.
All right.
Well, I guess we've covered things pretty fortunately. And so thanks for being here, Jeremy. And we will see you all next week. And I'll tell you what, I recommend people, because I'm posting info from this book into the Facebook group on legal search, specifically these calls. All right. I recommend join that group so that you can see some of these things. And this week I'll throw a list of words in there, definition words for you to look up, and just basic things you're going to run into in probably every case, things you need to wrap your mind around. So I'll put that in there. It's kind of a fun little side project for everybody. All right, Jeremy, thank you, sir.
All right, brother. Thank you all for having me, and God bless you, and I'll talk to you soon.
Everybody, absolutely. Have a blessed week. Thanks, guys.